Hello, and thank you for joining us for the last episode of the Analytics How-To webinar series. This episode will discuss how to make and use panoramic patentability studies. This is the 5th episode in a 5-part series. If you missed any of the previous episodes, you can find recordings on the SLW Institute on the SLW website. A recording of the webinar and the slides will be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu. Questions will be addressed in a Q&A session at the end of the webinar. We invite you to follow us on LinkedIn to see news about other upcoming webinars. Our speakers today will be Steve Lundberg, Janelle Callis, and Tom Marlowe. Steve Lundberg is Chief Innovation Officer and a founding partner at Schwegman, Lundberg, and Musner. He works with entrepreneurs, Fortune 100 companies, and a wide range in between, providing practical legal counseling and time-tested IP strategies. Steve will be joining us later in the presentation. Janelle Callis is an expert in analytics and a longtime principal at Schwegman, Lundberg, and Musner. She has expertise in chemical engineering, chemical and mechanical patent law, including extensive experience drafting and prosecuting patents for chemical engineering processes, food products, cosmetics, coatings, and medical devices. Tom Marlowe is president of Black Hills IP Renewals and Technology. He is a former chief patent counsel of Fairchild Semiconductor and private practicing attorney. He has been working full-time in patent analytics for nearly 2 decades. And with that, I'll turn things over to Janelle and Thomas.
Thank you, Michelle, and welcome everyone for our discussion of panoramic patent analysis. And I'm going to focus my section of this webinar mainly discussing white space and white space maps. Next slide. And I'm going to discuss with particularity kind of the history of white space and patent white space, where we've been and where we are now. Next slide. In general, white space is literally the space between text, graphics, images, and blocks. White space is also known as negative space or blank space. In business, a white space is where the unspoken, unmet needs of customers are discovered in order to spark innovation. It is a business process used to uncover opportunities. One example of using and identifying white space in business, quite a famous example, is McDonald's. In 1940, the McDonald's brothers were interested in starting up an establishment for selling food, a restaurant, but they recognized that times have changed. Their competitors did not recognize this, so their competitors continued to operate like a traditional restaurant, offering a wide menu with many types of foods and an expectation that customers would come into the restaurant, eat the food and then leave, or if they were in a car, that they would purchase the food and go to their car and eat it. The McDonald's brothers identified that times had changed and that people were interested in speed, but they were still interested in quality, and they were also very interested in eating in their car. So they limited their menu to 2 items, burgers and fries, and they focused on customer service and the quality of their burgers and fries. And they were extremely successful in capturing market share in a culture in which the car was king. They were very successful until Ray Kroc kind of took the business out from under them, but their idea was still genius, and they identified white space. Next slide. In the patent world, there are 3 types of white space in patent portfolios. 1, patents that cover products or processes not performed by a portfolio assignee. 2, products or processes not covered in a patent portfolio. Or 3, products or processes disclosed in a patent specification but not claimed. Next slide. In the 1980s and 90s, IBM identified the white space in its patent portfolio, which included patents covering products and processes not practiced by IBM. And they used these patents to generate at least about $1 billion in licensing revenue. IBM studied market products and compared new products to patents in its portfolio. They sent demand letters to companies making, using, selling, allegedly infringing products, and they set royalty rates low enough to discourage litigation and high enough to generate a substantial income. I was practicing law during this period of the early to mid 1990s, and I had several clients who received these demand letters. Typically in such a letter, IBM would not cite a single patent. They would cite at least 5 and sometimes 20 or more patents, which made the process of legally determining whether action and what action should be taken difficult, but in a sense easy. Typically, I think most attorneys, myself included, reviewed those patents to see whether they were even close to the target product. And what we usually found is that out of a list of 10 patents, there was maybe 1 patent which could be problematic. The rest we could usually dispense with. But that 1 patent was enough of a problem so that the demand letter could not be dismissed. In most all instances, including my own, we negotiated a royalty fee with IBM in order to make them go away. This was really the beginning of patent monetization using white space. Next slide. The IBM model and many other examples of monetizing patents using white space was famously described in the book Rembrandt's in the Attic, Unlocking the Hidden Value of Patents by Kevin Rivette and David Klein. This book was published in November 1999, and I venture to say that most patent practitioners had, or perhaps still have, a copy of this book on their bookshelves. It was a kind of a sensation because it was really the first time that I know of in patent history where companies could consider monetizing their entire portfolio. They may or may not have been successful, but at least they could consider monetizing. Next slide. Okay, so you've got a situation now where patent practitioners are woke. They're awoken to the prospect that they may be able to put a patent portfolio to multiple uses. They may be able to use it to generate income with respect to all of their patents, or at least the hope is out there based upon the IBM experience. Coupled with that is a huge change in the technological world, and that was the invention and development of the World Wide Web. Tim Berners-Lee is typically regarded as the inventor of the World Wide Web. And of course, this invention led to the development and creation of a plethora of companies that are still very, very important. These include Apple, Google, Facebook, YouTube, Instagram, Netflix, Uber, Spotify, Bitcoin, Venmo, and many, many more. Next slide. So the invention of the World Wide Web created white space that included new methods for doing business in virtually every area of commerce. So it's not only new business methods, it's also new software in order to implement those business methods, in order to create new products, in order to create new processes. It's like discovering a new world. Next slide. Okay, but one big problem is that business methods were not patentable. The vast expanse of white space created by the World Wide Web was not usable for patent monetization or even for patent protection. That is, until the decision by the Federal Circuit of State Street Bank. The case is State Street Bank and Trust, the Signature Financial Group, and it was decided in 1998. In that case, the Federal Circuit determined that software programs that transform data are patentable subject matter under Section 101 of the Patent Act, even when there is no physical transformation of an article. The court emphasized that software or other processes that yield a useful, concrete, and tangible result should be considered patentable. The court also laid to rest the business method exception. This means that while prior courts considered business method inventions to be unpatentable, the State Street Court found that these inventions were as patentable as other inventions. Thus, the white space model for business method patenting as well as for software patenting was open for business. And we had the equivalent of the great land grab of the late 90s, early 2000s. Next slide. Patenting in new business methods and software generally was the great white space idea in the late 90s, early 2000s. It was the dot-com boom. New business model opportunities were a result of the invention of the World Wide Web and a change in the patentability of business methods as a result of State Street Bank. And what this shows with respect to white space, it shows that white space can expand dramatically, or as we'll see shortly, contract just as dramatically due to changes in law. The same thing can happen as a result of changing technology. Thus, white space is not immutable, and it is ever changing. Because in this case, where it looked like there were no problems on the horizon, along came Alice. The Alice decision was Alice Corp versus CLS Bank Corp. And the Alice decision, which was a Supreme Court decision, established a two-part test to determine if a software patent was unpatentable under Section 101 of 35 USC for claiming ineligible subject matter. Under this two-part test, a court must first consider whether the patent claims are directed to a patent ineligible concept, such as an abstract idea, and if so, the court should consider whether the claim's other elements transform the claim into a patent eligible concept. Applying this two-part test, the Alice decision held that the known ideas are abstract, and reciting the use of a conventional computer in the claims to implement the known idea did not make the claim patentable subject matter. Next slide. The courts and patent examiners used the Alice decision and subsequent 101 decisions to render thousands of patents, perhaps tens of thousands of patents, unenforceable and invalid. Thus, the white space was bombed to smithereens, filled with landmines and rattlesnakes. And honestly, we are still fighting with this problem or dealing with this problem today. Next slide. Okay, thus far, we've considered these vast expanses of white space created by changes in the law and advancing technology. But there's another way to consider white space, and that is in terms of the space, the available space for patenting that exists around patents for inventions that are in commerce. One example that I'm going to discuss is the Gillette example. This is actually an old example, which was described in the book Rembrandt's in the Attic. Next slide. The Gillette company invented a shaver having tiny springs mounted to twin blades within a cartridge so that each blade moved independently along the contours of a user's face. They called this shaver the sensor. And it was an extremely important product for the Gillette company. Prospectively, they thought it would be. Retrospectively, it turned out that it really was. Designers invented 7 options for mounting the twin blades in order to protect those options so that they would not fall into the hands of competitors. Patent attorneys studied the patent landscape to determine which design could obtain the broadest patent coverage. 22 patent applications were filed on all features of the new shaver. Thus, the white space around the core patent covering the product was also protected by Gillette so that its competitors could not jump into that space and design around them and create their own product, or prevent Gillette from modifying its design in the future to employ one of these embodiments in the 22 patent applications. Next slide. Another, this is kind of an odd example, but it is interesting. Consideration of white space using product features is the Amazon one-click patent, which was US 5960411. Next slide. Now the one-click patent, claim 1, is as follows: a method of placing an order for an item comprising under control of a client system, displaying information identifying the item, and in response to only a single action being performed, sending a request to order the item along with an identifier of a purchaser of the item to a server system. Under control of a single action ordering component of the server system, receiving the request, retrieving additional information previously stored for the purchaser identified by the identifier in the received request, and generating an order to purchase the requested item for the purchaser identified by the identifier in the received request, using the retrieved additional information, and fulfilling the generated order to complete purchase of the item, whereby the item is ordered without using a shopping cart ordering model. Next slide. Amazon's one-click patent issued in 1999 and include features that foreclosed design arounds. Lord knows companies tried to design around that patent, but they couldn't. Their design arounds were not commercially successful, and they could not compete with the one-click patent. In a sense, Amazon's claim one is the perfect claim. Additionally, Apple and many other companies licensed the patent, but that was after they tried to have it invalidated. There were many validity challenges to the one-click patent, but it survived. It was in the right place at the right time. And it, like I say, it was also kind of the perfect claim for a unique product. So in that sense, Amazon kind of hit the jackpot in identifying and claiming the perfect white space in this commercial internet realm. Next slide. The idea that consumers could enter in their billing, shipping, and payment information just once, and then simply click a button to buy something going forward was unheard of when Amazon secured the patent in 1999, and it represented a breakthrough for the idea of hassle-free online shopping. Yeah, it's the type of claim that actually you don't see so much anymore. I think part of that is because of examination practices. But as I've said before, that claim represents kind of a capture of the perfect white space to protect their product while foreclosing competitors from making any inroads or blocking them in. Next slide. Thus, identifying white space can be done using product features, which are clustering and bracketing. Clustering is shielding an invention by patenting features usable to create a commercially viable design around. Bracketing is locking a competitor into a single patent to protect a product of interest. Next slide. Identifying white space requires predicting the future. It isn't enough just to generate a map and say, here's your white space. A company or patent portfolio acquisitions require a prediction regarding future markets and an understanding of a current patent portfolio's strengths and weaknesses. In one instance, looking for a patent holder is looking for compensation for patent portfolio weakness in a target patent portfolio. And that weakness may include a startup company that has patented technology that the acquiring company believes will be important to its future. Or in an older case, an instance where the acquiring company has recognized a single patent within a larger portfolio that actually reads upon their most important product. And in that case, they acquired that portfolio. So they locked in the white space and made it their own. Next slide. An important rule for white space identification is if you cannot articulate what you're looking for, you're probably not going to find it. And this is illustrated in possibly the first attempt at white space visualization. And these maps, they're topographical maps, were prepared by a company, I believe it was called Origin. And they looked really cool. I remember when they came out and thought, oh my God, this is really great. Until you start looking more closely at the map and determining what it is saying. And honestly, it is very difficult to decipher. You see peaks and valleys, but it's not clear what the peaks mean, what the valleys mean, where the white space is, uh, and what it means. Uh, Similar maps, which actually showed white space, faced the issue of the white, of there being a reason why the space was white. It either was related to products or processes that were thermodynamically impossible to perform, or products or processes that were not commercially viable. And it's white space, all right, but it's not really usable. So the lesson from this is that you cannot just generate a map and say, here's your white space. It has to be contextual with respect to the questions of the party requesting that visualization. Next slide. Okay, at this point, I'm going to turn it over to the brilliant Tom Marlowe, who is going to talk about panoramic patentability studies.
Thanks, Janelle. All right, so jumping into patentability studies, panoramic patentability studies, let's go to the next slide here. In a panoramic patentability study here, the goal is to take an analytical approach to patentability and invention type analysis. And yeah, as I say that, I realize that I just referred to taking an analytical approach to analysis. I think that might be a bit redundant, but what I'm trying to get at here is that maybe more of the visual aspect to analytics. Janelle just showed us one visual that is maybe not what we're looking for. They don't have to be these fancy charts or literal landscape maps that are difficult to comprehend. A lot of times it's just about a layout of data that allows for people to ingest and understand what it is that we're trying to convey more easily, and be able to draw conclusions and take actions. So in the case of a panoramic patentability study, we're going to focus on a matrix format for the analysis. Let's take a look at the next slide. So on this next slide, here's an example. So what we're looking at here is a matrix, a table. Across the top, so your columns, A, B, C, D, E, F, G, these are references, prior art, patents. They could be papers, they could be competitor products, things that may have elements related to, in this case, we're looking at a patent application related to elements in that patent application. So then you take that application and identify the different elements that that exist within it, and those turn into the rows. Disclosure element 1, 2, 3, 4, and up to 10. And then you simply have a project of mapping. Okay, does disclosure element 1 occur in reference A, B, not C, yes, D, E, F, and G? We mark that down and then go through. It's a little bit of work, but at the end of it, you have a matrix where you can quickly determine where each of the elements that are in your patent application exist. And these could be elements represented by claim elements, limitations of dependent claims, or even just embodiments that appear within the spec. So there's a number of different ways to use this analysis, but at the end of the day, we're trying to kind of winnow out what is a good space for patentability, given a set of references that help define the space that we're working in. So you can work through this. In this example, we can see a few elements: 4, 7, 10. We've used some color coding to help convey the message here. Those are colored green. Each of those doesn't occur in any of the references. So I might have something inventive in one or a combination of those items, or those combined with items that may occur in some of the other references. Depends on the technology, depends on how those combinations kind of would play out in reality, but this gives you a tool to be able to sit down and do that analysis without having to be flipping through all the references as you're doing that analysis. So if this is done beforehand, then you can sit down with an engineer or an R&D team and probably come to some good conclusions here. All right, let's take a look at the next slide. So in this case, this would be a similar type of analysis, but now we're looking at this in the development or earlier on R&D stage. So the engineering team or the design team is working on a new product. That product has some features, has some optional features, has some requirements, and the sooner that IP can get involved in that process and in that discussion, the better. The better on two ends. One is to make sure that the development goes without too many potential patent roadblocks found out kind of along the line. And two is so that patentable ideas can be found early on and protected, and we can get a sense of where the most value may lie. So in this case, again, we've got a set of references. Now, if this is a technology space that your company or your client's company is already working in, and we're developing a new product within it, we may already have a group of references related to past patent filings in this space. We might know who's playing in this space already, what they've been patenting. If it's a brand new space, new area that you're getting into, a search might be needed to help fill in these references. But at the end of the day, we've got some prior art we're going to be looking at. Again, A, B, C, D, E, F, G here in the columns. And then we take a look at the product being developed and we break out its features. And being, I would say, very conscientious of not restricting it to the exact features that are going into design, but also the potential alternative features and getting those listed out. And then it's a matter of doing the mapping. And we map out which features, in this case, product elements 1 through 10, occur in those references. And we pretty quickly get a sense of what might be patentable, what might be protectable. Now you also get the added benefit out of this analysis of getting some preliminary work on clearance or FTO type of analysis as well. So it's the double benefit. But from a corporate R&D perspective, this and engaging in this type of discussion early is incredibly helpful. In fact, Janelle, while you were talking and you mentioned Rembrandts in the attic, I turned around and grabbed it off of my shelf, and there's a section in it that talks about patents, patent protection, and R&D. And I remember there was a quote. I'm I've got it on this page here. In short, intellectual property can sometimes be the decisive factor in determining whether a company's R&D program leads to product success or failure, market dominance or share erosion, rising profits or falling margins. And I think that's a good point. And the more that you can identify what might be patentable around the subject matter that you're developing, well, the more you stand to protect that that you're putting into the market, and the more you stand to potentially gain from it as well. So that kind of leads us right into this next slide, which is about the value proposition. So like I mentioned, there's a lot of good reasons for doing this type of analysis. To help provide alignment between your R&D department and your IP department, to help provide potential guardrails, understanding that landscape and where the art currently lies. The more savvy those doing the development can be, I think the better development tends to flow. It also tends to wind you up with engineers and designers who are asking more questions and likely submitting more invention disclosures. Generally, at least that's what I found in my previous in-house practice. The reinventing point here is a particularly interesting one. And, you know, given, Janelle, what you were mentioning earlier with respect to IBM and their licensing program, I think I would especially stress this reinvention point if you have a licensed patent portfolio. So I happen to have been on the receiving end of IBM licensing. And when we finally signed an agreement, part of the value proposition there was actually not just having access to the patents that were being asserted, but having access to the entire portfolio, and being able to potentially leverage that. So in a lot of ways, not having to reinvent the wheel on some things. IBM, in that case, the portfolio we were licensing was quite substantial, still is. And there's a lot of interesting disclosure, a lot of interesting technology in there that by virtue of having licenses gave us access to those things. So when we were going into new technologies, understanding what was there and what was available, in a sense, it's not exactly white space, but it's also not exactly, say, forbidden space in that case for us to be avoiding, because we had access to it. So the same type of analysis can apply in understanding what it is that you might have access to that can help drive some of the development work that you're doing more quickly than if you did not. And of course, this is especially more pertinent if these are life of the patent type licenses versus termed licenses. You have to be a little bit more careful what you start incorporating into products. You know, but at the end of the day here, probably the most important part of this analysis, or any analysis, finally, once you've done it, is being able to communicate it in a manner that can be understood. Communication of data is really important in this type of work. And that's where when we look at what the analytics turn out, whether it's a matrix, whether it's a fancy map with peaks and valleys and islands, the question becomes, how can we make sure that this is good and ingestible, not just by the attorney, but by the client or the end user that has to use this to help drive action in business decisions. And that's where these simple matrix diagrams and tables work really well with engineering teams, because once you, especially with some color coding, you can very quickly see where there might be opportunities. Let's go on to the next slide here. All right, so when it comes to process of doing these projects, and frankly, the costs, they can vary pretty widely because these projects can vary widely in their scope, depending on the subject matter, the technical subject matter, depending on the scope of the prior art. You know, frankly, the amount of work that can be involved can be large. The key here, though, is to leverage tools as much as possible to reduce the labor that's needed. And the goal being to reduce the amount of time that's needed to just that which requires high value patent legal type analysis. So the more that you can do that, the better. As a rule of thumb, I think here, as you're going through references, you're going to focus on the earliest references first, getting to some of the more fundamental concepts for like an initial stage of analysis. And this type of thing is very easy to stage out. So you do an initial analysis, you see what comes out, or if nothing does, you learn from that, and then you build on it from there. Start with the early references, see what comes out as kind of potential around those, build in some of the more recent references as you go through this analysis, and you kind of learn along the way. You'll want to organize the references in a fashion that they can be easily analyzed and communicated, like I mentioned. The matrix design is particularly useful. At Schwegman, and when we handle analytics projects through Black Hills IP, we have a tool called Claimscape, which facilitates a lot of this. So it takes attorney input to a set of patents and references that have been preloaded into a system, and allows for a very streamlined mapping. That tends to be the time taker, is providing the mapping of the elements to the references. But once you've got that, you've built something up that's reusable and an output then that can be used when sitting down with a client or with an internal team, and kind of be able to leverage that time as efficiently as possible. Let's take a look at the next slide. Since I mentioned Claimscape, that's the tool that I end up using. That's the tool that's used at Schwegman. In addition to that, you're going to want to look at stacking on some other tools potentially in order to get the references that would be used in this analysis. Either you have them available, or you're going to have to do search. And if you're going to do search around the topic as well, you might consider leveraging some of the innovative prior art searching tools that are out there. Some AI driven tools are becoming very popular. An L patent comes to mind, but there's others. And basically with the idea being leveraging those things as much as possible so that you can optimize the time that the attorney spends and reduce the amount of time where that type of work has to be done with the engineering team or the client team on the line. All right, let's slide to the next page. Yeah, so that basically covers how the panoramic patentability studies are done. Obviously, there's a lot more details. If there's interest in doing these things and you're a client of Schwegman, or reach out. If you're not, you can reach out to me over at Black Hills IP and we can talk about assisting with these types of things as well. And now I think maybe we want to take a quick look at what the kind of the future holds here. And Janelle, you want to share some of your thoughts?
Sure. Thank you, Tom.
Yeah.
I would just like to add to Tom's comment regarding the power of the Claimscape. I have used it for quite a few years and find it to be an invaluable tool in identifying white space as well as other functions. In one instance that I can remember, I was in a teleconference with a client, and the business people and patent people were on the East Coast. The inventors were on the West Coast, and I was, of course, in Minneapolis. And I had loaded the Claimscape with appropriate prior art and had prepared a very nice Claimscape interactive map. And what we were able to do in that meeting is the inventors were able to see the power of it, and they instantly interacted with the map by asking questions regarding whether the product could include certain features or whether we could exclude certain features and still be free of any patent issues. And this would be virtually impossible without the Claimscape, especially to do it in a very short meeting. So I was sold on the Claimscape before this meeting, but it certainly showed the power of it and its usefulness in day-to-day practice.
Yeah, I love how quickly the data that comes out of that tool can be ingested, and that's kind of like the goal for any analytic that you're doing is how easily can it be kind of and acted upon.
Yeah, and I think the power of it is shown that the inventors take to it intuitively. Mm-hmm, mm-hmm. It requires really no training.
Right.
So in our final section, this is all conjecture. Who knows what's going to happen? But there are some interesting developments in the pharmaceutical industry, chemical industry, and semiconductor industry that point to this process being perhaps fully automated and taken over by artificial intelligence. Right now, pharmaceutical and chemical companies are using artificial intelligence to discover new drugs and new chemicals. Google had an article, I think it was last week, indicating that Google is using AI to invent new semiconductor structures. Google has used AI to make chip layouts that match or beat human-produced designs at power consumption, performance, and an area in less than 6 hours. Expert humans typically need months of iteration to do this task. A graph placement methodology for fast chip design, that's where their process is described, and that was published, I believe, last week in Nature magazine. Google said, "We believe that it is AI itself that will provide the means to shorten the chip cycle, design cycle, creating a symbiotic relationship between hardware and AI, with each fueling advances in the other. The AI is a reinforcement learning system. Reinforcement learning systems, unlike typical deep learning, do not train on a large set of labeled data. Instead, they learn by doing, adjusting the parameters in their networks according to a reward signal when they succeed. In this case, the reward was a proxy measure of a combination of power reduction, performance improvement, and area reduction. As a result, the placement bot becomes better at its task the more designs it does. Thus, patentability AI may be able to work in concert with design AI to determine available white space, both technical and patent, and optimal claims." Okay, so that's pretty much all we have for today.
And Janelle, one thing that I would add to that is there's an AI system called DABUS, D-A-B-U-S, that's been in the news as of recent in a bunch of different countries because it was designed to invent things.
Oh, cool.
And it's been in the news a lot because it's been put on patent applications as an inventor. And so there's a lot of controversy around, can you have a non-person inventor? But from a technical perspective, it's pretty interesting to see how it works because it goes and tries and solves problems, and what it's done to actually create the inventions is kind of in line with what we're talking about here. So if anybody's interested in reading more about that type of subject, I'd do a Google search for DABUS and you'll find plenty. Dr. Thaler, I think, is the creator of the system.
If there are no questions, I think we can conclude this webinar. Thanks very much for attending, everyone.
Yeah, thanks everybody. This has been an interesting topic. Yeah, I don't see any other questions over here in the queue.
Thank you for joining us, everyone, and thank you to our speakers. If you enjoyed the Analytics How-To series, we invite you to join us again for the Digital Transformation webinar series. The next episode of the Digital Transformation series will take place on July 8th, when we discuss an SLW digital transformation case study in due diligence, freedom to operate studies, landscape studies, portfolio curation, portfolio analytics, landscape analytics, examiner and attorney analytics. You can find the registration page on the SLW Institute on the SLW website. And please keep an eye out for the email invitations as well. Thank you again for joining us, and be well.